So hello everyone, Lior, pleasure to host you here on this edition of UX on Coffee. And before we begin, I want to introduce myself. My name is Avi Itzkovich. I'm the founder of UX Salon, which is a group dedicated to advance the profession of user experience design. We're based in Tel Aviv, and we're going to have a conference in March. You're invited in Tel Aviv. Go to uxsalon.com to learn more about the conference. But we're here on UX on Coffee, which basically means we both have coffees. Show me
I've got my coffee here. Yeah, sure.
And we're going to speak, we're going to talk, we're going to have a casual conversation. And basically, whenever our coffees are gone, conversation is over. Okay. Lior is an expert. Lior, how do you say your name? Zelering?
Zelering, yes.
Zelering. He's an expert on IP protection and user experience design, intellectual property protection. And I was really fortunate to host you here in Tel Aviv for a meetup last month on this topic. So I wanted to talk to you a little bit about intellectual property in user experience design. This is the book you wrote in Hebrew. It's a very thick book. Lots of words in this book. So Lior, tell me more. How did you start thinking about intellectual property?
Well, I did my first degree in law, and I didn't really touch the topics of IP. But when I did my master's, I thought to myself, how come somebody like me who's doing UX design, developing and doing all that stuff doesn't really know anything about IP? So I started taking all the IP courses they gave at the university. It was the center in Herzliya, the
IDC?
IDC, exactly, the IDC in Herzliya. And then I really got into it, but I was searching for a topic to do my thesis on. And I started thinking about all this kind of stuff about, contracts. The reason I started to study law was because I made really bad contracts. I was getting screwed over all the time when I did contracts. So I said, okay, something is wrong here. I'm going to, instead of hiring a lawyer, maybe I want to understand more what's going on. So it got me interested in that. So I started to, so I wanted to do a thesis, and I was looking for all these topics, and I was trying to find, when you do a thesis, you try to find your ID, okay? You're trying to find something new, something that haven't been done before. And I was searching all around, and it was actually kind of, have to say, under my nose, that actually the UX as a phenomena was not really covered in the legal aspects. So I started searching, and I was very surprised on how back this issue has been, discussed, like back in years. I mean, like in the 90s, in the 80s. Before we were talking about UX, people had problems protecting their, let's say, their flows or their designs, okay, in the aspects of computers. And when I started the research, and I did a very extensive research about that, I studied it for 2 years, okay? That's the time it took me, thousands of papers. I was really surprised on how much I found a topic which nobody really researched thoroughly. I'm talking about UX, okay? There were research about UI, but not about UX. So that's the thing that got me going on that topic.
That brings me to the question.
Yeah.
Which is the topic, which is what we want to talk about here. Is there a way to protect an experience? What is an experience? How do we define it so we can protect it legally, by the way?
Yeah, so this is a great question, but it goes back even a little bit further than that. When we're talking about design, we have some issues about IP and design in general, okay? Because IP is made of, let's say, 3 or 4 disciplines, maybe a little bit more, but let's say the big ones are patents, which protect inventions. We got copyrights which protect, let's say, more artistic creations such as, songs, lyrics, that kind of stuff. Also paintings, okay? We got and we got the last, let's say, big one is trademarks, which protect logos and that kind of stuff, and also trade dresses, how a product is designed. Inside patents, we also have design patents, where utility patents are how things work. Design patents will be how things look, okay? So even patents are kind of divided to the working things, or the things which are, let's say, are systems, and things that are only designs. And the most important aspect of those, let's say, groups is that you can't protect anything functional except by patents, okay? So copyrights can't really help you protect a design if that design is functional. So the question I am asking in the book actually, is UX functional, or is UX something arbitrary, which is more about feelings, more about, branding, you know what I mean? Because that's the main question. If it's functional, we're going to have a harder time to protect. But if we can convince the judge or whoever it is that our design has something which is more artistic, more abstract, more towards the branding things, we might convince them that we can have that protection. But the important thing is, if we push it towards branding and say, okay, our design, our UX is something that is kind of like an experience we designed, which is a part of our identity, which means it's our trademark, okay? Then it still can't be functional. So that's the big problem we got. So there is this case called 2 Pesos, which was talking about how you design a restaurant. So there was this restaurant that was designed in a very special way, very festive way, with a great atmosphere, and they got protection because they had those features of being very festive, being very, have a very unique design in the restaurant. And that kind of, that case actually, it had another feature, but let's say that case of saying we can protect an atmosphere, we can actually use that in UX as well. We can say the UX is an atmosphere. It's not functional as it is funny, it is great, it is surprising, all the things we try to put in UX to make us different than just a simple, let's say, UI task, okay? So if your design is going to be very, very functional with a very simple UI, you might have a hard time protecting it unless you go to patents or you go to a design patent, which is fine.
So a function is like swiping left, or what is a function?
A function would be that the judge sees your design as a VCR. This was one of those cases. I think it was in Lotus 123. The judge said, "Look, you did a beautiful menu. It's very innovative, but you are showing me a VCR. You're showing me a play and stop button. This is how I see it. I don't see anything about experience. I don't see anything about a special design. So if we're talking to be about an interface that helps a program, an operator operate the program, this is nothing that can be protected in copyrights. You can try and patent it if you want to, but this is what I'm going to give you, okay? But if in other cases, like there was a case like Jaslow, so in those cases, if the judge says, okay, I see here something creative, I see here thinking, I think people can do this kind of idea of an app or a program in other ways, that means you have something creative here, and I'm going to protect that because you put your work into it and it's creative. So I'm going to give you a copyright protection, which is, by the way, for 70 years after the death of between 50 and 70 years after the death of the inventor or the creator. I'm going to give you that because I think you did a creative process here, which I'm going to protect. You don't have to go and patent it. I'm going to give you the simple copyright protection. So some judges will say, go and patent it. I don't care. And some would say, I see the UX is a creative process. I see there is something special there, and I'm going to give you that protection. So, by the way, this was something that was going back and forth between the 80s and the 90s until the Lotus 123 case, which the judges said, look, we're not going to protect anything which is a UI or UX through copyright. If you want, you might want to protect it by patent or a design patent. That's all we are going to do. And this is actually the case in the US now. So in the US now, you'll have a hard time protecting through copyright, but you might try to patent it, and you might try to design patent it, and you might go through the trademark route, say, okay, this design is very special, and it's my trademark. And those things can work. It's hard to do, but it might work. This is, by the way, the Apple way. What Apple is doing, actually, they're taking the product, they're dissecting it, and they're saying, we're going to put the UI through design patent. We're going to put a utility patent on the phone itself, and we're going to even copyright and trademark all kind of other features. So they're dissecting the product into different categories and protecting each part of the product through one of those, one of those tools, either patents, trademarks, or design patents.
So I understand that there's no one protection for an experience. You have to kind of try to dissect it.
Exactly.
Is there examples of this, like application? For example, if I invent a certain like feel, or I think there's an app that swipes that shows information in a very unique way, animation.
You can try and write a design patent for animation. Apple did that. But if you're telling me I want to take the whole UX experience and I want to copyright that or protect that, that's not possible. In my book, I think about ways which you can do that. And I think there is a way that you can give inventors, from my perspective, the UX invention should be copyrighted or protected as a whole. That means you would submit your screens, your animations, your ideations, the whole process. You'll just all the specifications will be submitted, and you would, if it's inventive enough, if it's unique enough, you would get protection for the whole user experience, but that would be only for 2 years. Okay. You get a very strong protection, like patent, but only for 2 years. And the reason is because when you look at the progression of UX, you can see that companies are changing the UX by themselves every 2 to 3 years, okay? You can see that in Facebook, in Apple, all those companies. So it's kind of weird that Apple is going around and protecting their UX for 7 years in design patents, 14 years in design patents, 20 years in utility patents, but at the same time, after 3 years, they're throwing away their UX and just starting a new one, okay? So they got all this protection of back versions, even though they're not using it. So that's kind of weird, right? So there is no protection for UX. I say there needs to be a protection for UX. It needs to be very strong, but only for 2 years. That means that if Instagram made this great app, which has great features, it got the filters, and it's got all that stuff, and the complete experience, you can't really dissect it. So I'm saying, okay, let's protect Instagram for 2 years. You want to do a photo sharing app, you can do whatever you want to, just don't copy Instagram. You can just think about other options, be creative, put your head into it, and I want to see a lot of Instagrams, okay? Then the market will decide which Instagram is the best one. After 2 years, 2 years is enough time. And after those 2 years, Instagram will completely lose the protection because they already marketed, they had their time to market, They had their opportunity to get the market, to get the users. After that, you can copy Instagram as much as you can. But until then, you can't touch them for 2 years. I mean, it can be 3, but from my perspective, it would be 2. But the reason is because I want to see a lot of Instagrams. I don't want to see copycats copying apps from one each other. I want to see people being creative about ideas. So the idea would be a photo sharing app. I want everybody to create their own one, and I want the market to decide which one is the best.
So just to kind of be clear, you don't want to see a lot of Instagrams. You want to see a lot of similar experiences. That's what you mean.
Yeah,
right?
I want to see a lot of photo sharing apps with great designs, with creative people. Instead of copying the same one, just be inventive and do something completely different. That domain would be protected. You cannot touch it. You can just do things that are similar. Yeah.
Is there any apps or any experiences that you saw that were protected, that are like domain, like keeping that? Do you have any examples?
Well, there is a lot of things in between, because what the companies do is what I tell you. They sector protection. So Facebook has a lot of design patents on their. I showed it in the talk I did. They protected their icons. Like the friends icon, they protected their all kind of UI. But again, you can protect the UI, but not the UX. You can protect how it looks, but not even the colors, because design patents don't have the colors in them. So you can protect all kind of stuff, but you can't protect the whole experience, because you can protect the animation sometimes, but you can't protect other stuff. So one thing would be to protect just the UI. And through design patents, that's what Facebook is doing, that's what Apple is doing, and then you can protect the algorithm. Okay, let's talk about the newsfeed. You can protect the newsfeed as a screen, as a UI, but this is just the UI. What about all the psychology behind it, which is the UX? Okay, so what Facebook did is actually wrote a patent on the newsfeed. Okay. So they have a patent on the psychological aspects of showing feeds to people, and they got a design patent on how it looks. But it's still not fully protected. You know what I mean? Because you can think about a process like that, like showing news to people in a different way, which is not that specific UI. So it's kind of in between. Okay.
It sounds like it's going to be very complicated for someone who's just designing an app or a startup to start thinking about these things. What's your advice there? How does it?
Yeah, that's a very good thing. That's a very important thing you're saying, because the thing is this: people are designing apps all the time, and they can get ripped off really easily. Okay, really easily. You can do that because. While applying to a design patent might be less costly, you still have to do it for some screens. And issuing a patent, like a utility patent, it's a very expensive and long process, and you have to be very inventive. So this is kind of a tool that the big guys are using to, protect themselves. So Apple did it to Samsung. They won like $1 billion, more than a lot of money. I mean, the thing about Samsung, it was a lot of different cases and different, things they did there. And Apple also sued HTC in Europe. And so, they got all these things going around. The people who are making the money are the lawyers, okay? They're making tons of money, yeah? But the thing is, they're using it to fight each other. A good example would be the one-click patent from Amazon, which they just sued Barnes and Nobles over it because they copied it. So that's just a tool they're using. So the big guys are doing their thing and they're controlling that. But a small entrepreneur that thinks that he's got an amazing design, which he doesn't want people to copy, the most immediate thing would be to do a design patent, okay? Which means just the layout, not really the how it works, just how it looks. And that would be the most. I think it will be cheaper, much cheaper than doing a utility patent. But if you got a great story behind the product and a great algorithm that is doing really interesting stuff, you might try and issue a patent itself, even though it costs a lot of money, but that's only after you get some investors inside and you get something going, you know. Other than that, you can always try to sue on copyrights. It depends on which country. It might work well in Israel, for example, but it might be very hard to do in the States. So it kind of depends on the country, on the judges. So you might want to sue over copyright. And if you're very successful, you can try on trademark also. But on trademark, you have to convince the judge you have something unique that the people already used, that people know. You have to explain that this is a trademark, which you can't do it right off the bat, you know, with two users. You know, you can't trademark two people, you know, using your app. So you have to get some kind of community around it. So it can be trademarks, it can be copyrights. It will be hard in the States, but it can be still in the States. Design patents and patents are are stronger tools that cost more, but they are more. Let's say they are more substantial to protect your inventions.
Okay. I want to say first of all that we're running out of coffee. So
yeah, okay.
I'm going to have to make it short, but
yeah.
I want to say, one more thing. This is not a legal advice whatsoever. This is just a conversation.
Oh, yeah, exactly. Thank you for saying that. All I'm saying is just academic research. You can use my ideas, but you have to talk to a lawyer and get your advice from them. Those guys are up to date with everything, so just do that. You can tell about the ideas we're talking, but just tell it to a lawyer.
I will share the link below for the book. Yeah. So if anyone is interested, could read more about this. There's a lot of good material here. Lior, thank you for your time spending with me having coffee. And
thank you very much, Avi. And I gotta tell you, I really like UX Salon. I think it's one of the best things there is around. And I urge everybody to stay tuned in and see all the things that are posted there, which are very, very good and exceptional.
Well, it's a good opportunity to remind people to subscribe below and get more updates on this. Thank you, Lior. And,
thank you very much.
Talk to you soon.